Hello friends, welcome to our YouTube channel. Friends, in this particular video, we are going to overview litigation and enforcement in Australia by Richard Harris, Christian Lynch, Marshall McKenna, James Fleming, and Selma Patrick, Gilbert plus Tobin. The country-specific Q&A gives a structured overview of the key practical issues concerning dispute resolution in this jurisdiction, including court procedures, fees, and funding, interim remedies, including attachment orders, disclosure, expert evidence, appeals, class actions, enforcement, cross-border issues, the use of ADR, and any reform proposal. Main dispute resolution methods. What are the main dispute resolution methods used to resolve large commercial disputes? The Australian court system is based on the common law system and is therefore uh, adversarial by nature. The main mechanisms available to parties seeking to resolve large commercial disputes in Australia are though a combination of court-based litigation and alternative dispute resolution processes. Litigation The litigation process requires each party to appear in court or tribunal and to present evidence and arguments. The appropriate forum to hear civil disputes is largely determined by monetary limits imposed on courts and tribunals in each jurisdiction and the relevant status that apply to particular dispute. ADR can be entered into voluntarily or by court order. The most common forms of ADR processes used in large commercial disputes are mediation. Mediation is a negotiation process that is structured and facilitated by a neutral third party or mediator who assists with the negotiation. The mediator can be appointed by a court or privately agreed by the parties. A mediator cannot make binding determinations but may express views to facilitate the negotiation process. Most court rules and practice notes contain procedural requirements for parties to attend some form of compulsory mediation at some stage of the proceedings. Arbitration. Arbitration is a referral of the dispute to a neutral third party or arbitrator for determination. Arbitrators can make interim and final awards. One or more arbitrators can be appointed. A referral to arbitration is usually a contractual requirement of an existing agreement. Alternatively, arbitration requires the agreement of both parties. Arbitrations are usually conducted in a manner similar to court litigation, but the hearing and determination of an arbitration are private and confidential. Australia has a separate regime for international and domestic commercial arbitration. Expert determination. In matters involving technical issues, it is not uncommon to refer issues to an expert for determination. The process is similar to arbitration but involves referral of a matter to a subject matter expert uh, who is able to express views based on her or his experience rather than merely deciding a matter based on the evidence presented. Generally, Australian courts have enforced agreements requiring parties to refer their dispute to an ADR process, including by staying uh, proceedings pending the outcome of that referral. Court litigation. Limitation periods. What limitation periods apply to bringing a claim and what triggers a limitation period?